You may have heard about the shocking sex abuse lawsuit being leveled at WWE boss Vince McMahon by a former employee.
Former WWE employee Janel Grant accuses McMahon of sexual assault and trafficking.
The scandal couldn't come at a worse time as the WWE signed a massive $5 billion deal with Netflix.
The lawsuit, Janel Grant accuses McMahon of sharing sexually explicit photographs and videos of her with the wrestlers and recruiting men to have a threesome at the WWE headquarters.
Everyone at the WWE has reportedly been told to not say a word.
Do you believe her? Do you believe Janel Grant?
Oh, again, I don't know enough about the information to give you a good enough answer there. I'm sorry.
The parent company of WWE says they take the accusers' quote, horrific allegations very seriously and are addressing the matter internally.
If you guys haven't heard, there's been an update in the Janel Grant versus Vince McMahon and WWE case and regarding a lawsuit that was done in 2024 due to some SA allegations that started a chain reaction which resulted in Vince McMahon leaving the WWE permanently, as far as we know. And other people accused along the way, which include John Laurinaitis and supposedly an MMA fighter. We don't know who it is, but what we do know is Vince, WWE, and John Laurinaitis based on the court document. Yeah. WWE versus Janel Grant. So, we're not going to talk about people that we can't prove. We can only go based on the descriptive document. Anyway, before we begin, it is critical to be very clear about this video and what it is not. Everything discussed here is based on publicly available court filings, official judicial orders, and reporting from reputable news organizations. This lawsuit is ongoing. No jury has been seated. No final ruling have been issued, and all allegations remain allegations unless and until they are proven in court. This is not speculation. This is not rumor. This is not a verdict. This is a structured explanation of where this case stands right as of now, why a recent ruling matters, and what happens next based on the information we currently have. With that foundation set, let's get into it. Foremost, in the past year, the lawsuit filed by former WWE paralegal Janel Grant against Vince McMahon appeared frozen. There were no dramatic court hearings. There was no public discovery. There were no document dumps or depositions. To many observers, it felt like the case had been stalled out. That assumption is understandable, but it is incorrect. What was actually happening was a procedural pause, something extremely common in federal cases involving powerful defendants, arbitration clauses, and non-disclosure agreements. The silence was not absence, it was a process. This week, that process finally moved forward, and the way it moved mattered far more than the headline. Now, let's reset for new viewers on what happened in January 2024. To understand why the recent ruling matters, we have to go back to January 25th of 2024. On that day, Janel Grant filed a lawsuit accusing Vince McMahon, WWE, and John Laurinaitis of SA&S trafficking and prolonged abuse during her employment with there you go. So it's very clear. According to the complaint, Grant alleged that McMahon used his immense authority as WWE top executive to coerce her into SA acts promising career advancement, financial stability, and reputational protection that never meaningfully existed. Now, yeah, so right here, Plaintiff Janel Grant is a former employee of WWE who was the victim of physical and emotional abuse, SA, and trafficking at WWE. As such, when McMahon pushed Ms. Grant for a physical relationship in return to long-promised employment at WWE, she felt trapped in the impossible situation, submitting to McMahon's demands or facing ruin. Ms. Grant feared she had everything to lose and faced negative consequences no matter what happened. The lawsuit further alleged that Grant was trafficked to other people, including WWE executives and unnamed high-profile talent, as part of a system that designed to secure loyalty, silence, and business leverage. One of the most serious allegations states that in June, and before we get that, there's another statement in this thing that should be important for this, which is in March 2020, McMahon began sharing explicit photographs and videos of Ms. Grant with other men both inside and outside the company, including with members on television production tech teams, executives, producers, and a world-famous athlete and former UFC heavyweight champion with whom WWE was actively trying to sign to a new contract, and ultimately did sign a contract. Given McMahon's omnipotent position at WWE, Coercion was inherited in his increasingly depraved demands. Specifically, while McMahon was CEO of WWE and Ms. Grant was employed as an entry coordinator in the legal department, McMahon recruited individuals to have relations with Ms. Grant and or with two of them. Directed Ms. Grant to visit. She was directed to visit defendant Laurinaitis prior to the start of workdays for encounters, and expected and directed Grant to engage in such activity at the WWE headquarters even during working hours. So now based from that was March 2020, we fast forward to June of 2021. McMahon and Laurinaitis allegedly locked Grant in an office and started doing stuff while other WWE employees were present in the building. So based on the case doc, is stated in June 2021, McMahon and defendant Laurinaitis attacked Miss Grant inside Laurinaitis' office in WWE headquarters while colleagues were busy at their desks. So this was during work hours? Behind a locked door, the two men cornered her and pulled her in between them, forcibly touching her before ultimately putting her on top of the table. She begged them to stop, but they forced themselves each taking turn restraining her, and said mean things like no means yes and take it, bitch. Unsurprisingly, others at WWE knew what was going on because they were there when this happened, but instead of intervening to protect Ms. Grant, WWE actively sought out to conceal the wrongdoing. Now, who was there? Who knew what was going on? It could be staff workers, people who work at WWE headquarters. It doesn't necessarily mean wrestlers, but who knows who was there. The obvious one is probably workers, like office workers. Now, the legal claims include violations of the Trafficking Victims Protection Act, civil battery, intentional or negligent infliction of emotional distress, and negligence by WWE for allegedly enabling or ignoring the abuse. The complaint was not vague, it was detailed, it was graphic. As you can see, it was severe. The day after the lawsuit was filed, Vince McMahon was resigned from all WWE roles in its parent companies while publicly denying the allegations. That resignation did not prove guilt, but it did confirm that the case was not trivial. Now, let's go to a statement that framed the case from her lawyer. When the lawsuit was filed, Ann Callis of Holland Law Firm, who submitted the complaint on Grant's behalf, issued a statement that framed the case in unmistakable terms. And this is Callis right here. Callis said, today's complaint seeks to hold accountable two WWE executives who SA'd and trafficked plaintiff Janel Grant, as well as the organization that facilitated or turned a blind eye into the abuse and then swept it under the rug. That framing matters. That was never presented as a private dispute. It was presented as accountability case. And Callis continues, she is an incredibly private and courageous person who has suffered deeply at the hands of Mr. McMahon and Mr. Laurinaitis. Ms. Grant hopes that her lawsuit will prevent other women from being victimized. And then she concluded with this. The organization is well aware of Mr. McMahon's history of depraved behavior, and it's time that they take responsibility for the misconduct of its leadership. From day one, this case was framed as larger than one individual. Now, even though that's all happening, there's another situation at hand. There's the NDA of this and why it controls everything for this case. At the center of this whole complaint or lawsuit is a $3 million non-disclosure agreement. Grant alleges that she was pressured into signing the NDA after years of attacks, manipulations, and career threats. She claims it was presented as protection, but functioned as enforced silence. Critically, the NDA includes a clause requiring disputes to be resolved through private, binding arbitration rather than a public courtroom. Now, this is not a technicality. Arbitration is confidential. Evidence does not become public. Depositions are sealed. And this is as much as we're going to get with explaining because it's very deep into the weeds. But anyway, internal emails may never be seen publicly or at all, maybe. In this case, if it's forced into arbitration, the public may never learn what documents exist or how decisions were made inside WWE. That single clause is why every step in this case has been deliberated, slow, and contested. Now, what Grant's legal team recently attempted. So, Grant's legal team recently filed a motion asking the court to allow early discoverability. Now, what is discoverability? Discoverability is the phase where cases become real. But without messing up and butchering that statement, I'm just going to let this man explain it for us for the sake of clarity.
Using a lot of legal jargon. And I'm going to explain one of them to you today. Client asks, well, what's the next step? And I said, well, we're waiting for discovery. Now, what the hell does waiting for discovery mean to somebody that doesn't play in the criminal defense sandbox? Well, what that means is that in Florida, we are entitled to have a fair fight and a fair trial where each side knows what the other side potentially could present to the jury. And when I start a criminal case, I demand discovery up front, meaning I demand every sworn statement, police report, body cam, 911, lab report from FDLE, expert report, every witness they talk to, every recording, you name it. That is called discovery. It's a process of discovery, and it's ongoing. We get like a tsunami of information as a defense attorney when we first get hired. I mean, it can take a couple months for them to turn it over, of course. We're not really entitled to discovery until the state files formal charges. So sometimes you'll get arrested. I'll demand discovery, but I'm not going to get it until they decide, yeah, we're going to file charges. Then I get it. And even then it can take a little while. But the point is, we are going to have a fair fight on this. I am going to disclose whatever I want to use at trial. They are going to disclose everything. And because the burden is on them, not on us.
Wow.
And discovery is not just all those reports that I'm going to demand and get up front. I get to do depositions as well on felony cases, sometimes on misdemeanor. And depositions, that's another fancy term for I sit at a table with a witness, they raise their right hand, and I start asking them a bunch of questions. What do you know about this case? That's a deposition. We write it down, and then there's no surprise at trial. When they show up and maybe they didn't do a sworn statement, maybe they did, and maybe their deposition differs from what they said at the scene, and maybe it even differs again what they say at trial. That's part of the discovery process, those depositions. The state has really pretty high obligations to supply us everything, even supply us stuff that hurts their case.
So everything gets...
Call that Brady material. It's exculpatory evidence. You cannot, as a prosecutor, hide the ball on us. If you have some good stuff that would help us, you've got to turn it over. We call it Brady material. In the end, look, the discovery process is designed so that we have a fair fight. There will be no trial by an ambush here, no surprises. Everybody knows what's on the other side, what could be presented, and we know what we're going to say in response to that. That's a fair fight. That's what the discovery process is trying to get us to. I caught myself.
So basically, it's where every document possible is produced. It's where emails are produced. It's where corporate policies are examined. It is where timelines stop being theoretical and they get the hard facts. So Grant's attorneys requested access to communications involving WWE executives, subsidiaries, and its parent companies such as TKO and Endeavor. They also sought records related to payments made to multiple women, WWE's SA policies, and travel records connected to Vince McMahon, John Laurinaitis, and so on. The strategy was clear for Grant. Grant's team wanted discovery to support their argument that the NDA and its arbitration clause should not apply if it was tied to alleged illegal conduct. Now, this is where WWE's defense responds. The defendants opposed the motion. Now, I have pictures of multiple different lawyers because I don't know who their lawyers are. I mean, there's this guy over here who's the official law firm partner of WWE, which I think is just for advertisement. So it may not be true. It used to be Jerry McDevitt Esquire, but he's ever since retired. Or it could be David Ortunga himself. He's a Harvard law lawyer. Just so you guys know, this image is just for imagery. I don't know who their lawyer is. Just imagine it might be one of them. Who knows? Anyway, the defendants opposed the motion. They did not argue guilt or innocence. They argued that discovery would be premature and potentially wasteful until the court decides whether arbitration applies. Now, all of this is happening in Connecticut, and under Connecticut federal court rules, discovery can be delayed until motions to compel arbitration are resolved. So basically, can't do this process until arbitration is figured out. So it's a standard procedure when it comes to cases involving NDAs, which probably WWE or Vince McMahon at least knew that would benefit them. The defense position was procedural, not substantive. Now, when it comes to all this, based on their defense, the judge ruling and pretty much came about this week. After all that, the judge responded. In her own words, the judge basically this week denies the request for early discovery, but how she said it is critical. The court's written order status states, and just so you know, the judge for this case at this moment is Sarah F. Russell, who is the judge of the United States District Council for the District of Connecticut. So she states, the court's written order states, plaintiff, which is Grant, seeks discovery to support federal grounds for avoiding arbitration. The court expresses no opinion as to the merits of these forthcoming arguments or any other grounds that plaintiff may choose to assert in opposition to defendant's motion to compel arbitration. That sentence matters. The judge is explicitly stating that she is not ruling on whether Grant's arguments are valid or invalid. She continues saying, but the court has determined that it cannot evaluate from the current record whether discovery from defendant is required to resolve the applicability of defense plaintiff may rise to arbitration. So, it took a while, but in plain terms, the court is saying that it does not yet have enough information to determine whether discovery is necessary. The order then states, thus, the plaintiff has not met her burden to show good cause for taking discovery before responding to defendant's motion to compel arbitration. Now, this is the pause for this whole time for this case. And then comes the most important line. Plaintiff may renew her motion for leave to take discovery in conjunction with filing her response in opposition to defendant's motion to compel. After reviewing the briefing, the court will determine whether to permit the parties to take limited reciprocal discovery. So that is not them denying, doing a denial of the merits. That's them creating a procedural checkpoint. So they're just going by the book at this point. So now with all that legal jargon, what does that mean in real freaking terms? The court is effectively saying that file the arbitration arguments first. Then she will decide what evidence is needed to evaluate them. The case is now moving again after all this pause, after 7 months of inactivity. Once the defendant filed motion to compel arbitration, Grant will be allowed to respond, and at that point, the judge may permit limited discovery. Nothing has been dismissed, nothing has been decided on the merits. It's just this at this point. Continuing. Now, why does this case still matter at this point with all this pause and inactivity? Simply put, this lawsuit is not just about Vince McMahon. It is about whether NDAs and arbitration clauses can shield alleged misconducts of this magnitude from public accountability. The central question remains unanswered. Will the case be examined in open court or resolved behind closed doors? That decision has not been made yet. So let's be absolutely clear about what just happened here. The court did not say Jeanette Grant's claim lacked merit. The court did not say the allegation against Vince McMahon are weak. The court did not rule that arbitration is appropriate. What the court did say, though, in its own words, is that it cannot yet evaluate whether discovery is required because defendants have not yet filed their arbitrations motions yet. So they're not exonerating at this point. They're just going by procedure. And it matters, and this needs to be clearly noted more than any headline that's online right now. This case is still standing. The allegations are still on record, and the door to discovery is still potentially open. The judge explicitly stated that Janel Grant may renew her request for discovery once the motions to compel arbitration are filed, and that the court will then decide whether limited reciprocal discovery is necessary. If I can translate for you on that, basically means the evidence has not been buried, has not been dismissed, and it has not been ruled irrelevant. It is waiting. And here's the uncomfortable truth that no press release will say out loud. And if this case reaches discovery, it will not be about vibes, narrative, or damage control. It will be about emails. It will be about travel records. It will be about payments. It will be about who knew what and when. That is why arbitration is being pushed so aggressively by the defendant. Because arbitration does not expose systems, it contains them. The lawsuit already forced a resignation from the most powerful figure in WWE history. It has already reshaped corporate leadership and is still in its earliest procedural phase. So if anyone is telling you this case is over, or that the court shut it down, or that this was some kind of victory lap for the defense. They're not reading the rulings clearly, or at least getting it translated. This case is not loud right now because the legal system moves slowly. But silence does not mean safety, and it doesn't mean a case is dying. It means pressure is building, and when the next filing hits, the question will not be accountability. If accountability is coming, it will be where it happens in public or behind closed doors. So hopefully we find out more about this in the few weeks to come, and maybe they'll follow suit with the right procedure so we can get this going and out of our lives once and forever, because I do not want to hear about this case anymore. I hope everything gets resolved and justice is served. So with that said, strong brew, no salt behavior. Let me know in the comments what you think will happen next in this case,